going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. Oh, I've got a good one. Judge Elmore out of Michigan. Where in Michigan? Wexford County, I believe. I don't know. He's one of those judges that he's in two different jurisdictions. Wexford's one of them, and I don't remember the other one off the top of my head, which I think is the one he's in. Anyways, doesn't matter. It's Judge Elmore. He's in Michigan. All right. This one is interesting. I've watched this. I haven't watched it straight through. I've watched bits and pieces of it because it's long. It's about 50 minutes long. But I still don't really know what the attorney is so frustrated and angry about. Don't really know. Every time I keep going back so I can put a little, blurb together in the description, still can't quite figure it out. So hopefully we can figure it out together. But he is angry. He does talk back to the judge. He does interrupt the judge a lot. Doesn't end up well for him. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
This morning from the 28th Circuit Court here in Wexford County. And we begin today with the people of the state of Michigan versus Jeffrey Allen Maxson Jr. This is case number 23-13666-FH. Appearances, please.
Morning, Your Honor. Corey Wiggins on behalf of the people. Dan Burns on behalf of Mr. Maxson, Your Honor.
Thank you. Mr. Burns joins us for the record today via Zoom. And then also joining us today via Zoom from the Michigan Department of Corrections is the defendant, Mr. Maxson. Mr. Maxson, are you able to see and hear the court?
Yes, Your Honor.
All right, thank you. Taking just a moment to review.
Yeah, I'm in 10th place. My team is terrible, and I just lost one of my best players on the first play of the game on Sunday. So, yeah, not looking good for me, but hopefully we bounce back. It's still early. And Heather is beating everybody. Heather's in first place. Go, Heather. What's up, Jay?
File again. We are here today for a motion post-judgment filed by the defendant. It's entitled the defendant's motion to correct an error and or for relief from judgment. Court has received a brief filed by the defense. I'll note that I had to take some time this morning to read it. It may have been an error someplace in mailing, but the judge's copy was not received in my office until 26th. Then received a response filed by the government on the 27th. I had to take some time this morning to read it as I left the office early on Friday due to some health issues. So again, we're here for that motion. Now I'll note that it appears that the motion is filed pursuant to a court rule 2.612. So if that's the right court rule. Start talking clerical mistakes, I think we're generally looking at 6.435 moment.
I believe it's the same standard, Your Honor, but that may be right. I may have referred to the civil, the relief from judgment. It's a general, actually. It's 2.612 does not limit the authority of the court to civil matters, but certainly if 435, the standard is the same, effectively, for a ministerial mistake such, or just a ministerial mistake such as this.
One second. My reason for pause is I needed to review the other court rule. This motion is entitled motion to correct error and or for relief from judgment. The reason why I paused is because I wanted to again review Michigan Court Rule 6.502, which judges are quite familiar with because we receive them a lot from defendants themselves. 6.502 states that there are certain requirements for a post-judgment relief motion, and when the court finds that it may not meet their requirements, specifically the form of the motion underneath Section C of that court rule, the court can return an insufficient motion under Section D. I don't think that the second portion where it says relief from judgment is necessarily proper, because I don't believe that they've covered every term, but we'll still go ahead and consider it. Although I can't tell the court, I'm sorry, the defendant, that the court can consider it as a motion for relief from judgment. I'll highlight, though, as I'm required underneath the court rule, to inform the defense that the court will choose to treat it as a motion for relief from judgment, and they're only entitled, the defendant is only entitled to one such motion ever. All right, Mr. Burns, I turn the floor over to you.
First of all, I object. That is not the, this is a clerical error to the degree that it's being characterized as a substantive or a discretionary error. I object to the notion that it's being brought under a rule in which we only get one attempt to make the correct filing with the court, to the degree that we have.
Okay, hold on. Yeah, hold on. You can object, that's fine. Then I'm going to strike off here, off your motion. This court will not consider it as a motion for relief from judgment. The court will only look at it as a clerical error. Again, like I said, I have the responsibility of informing the defense. This is what the court's going to do. Then the defense can respond to that, and therefore I will therefore not apply the burdens of proof and standards of review as a motion for relief from judgment. I will strike that from the motion and only consider it a motion to correct error. All right, thank you, sir. The floor is yours again.
Again, for purposes of this motion, I object to the notion that it is being, it is one bite at this apple, as the court has characterized this, that there's only one ever motion for relief that the defendant may have. To the degree that a motion for relief would equitably apply under the circumstances, I'm going to leave it to the court under these circumstances to see whether or not they feel that this is a ministerial or discretional decision made that I am taking exception to, which I don't believe it is. I believe this is purely ministerial, and therefore it is a clerical error, and there is no relief from judgment that we're seeking underneath that standard. We're seeking just a correction of the judgment underneath the correction of the judgment for a clerical error, which would cascade into changes potentially in the judgment. But the clerical error is fairly straightforward. We've discussed this at a number of hearings, and it's a clerical error that took place in October of this place. It's undisputed. Mr. I do see the brief. I also got it late. I just got it this morning as well. I didn't have the full brief until 10 minutes before this hearing. And other than the ad hominems and other than the timing arguments, there's no dispute and there's no objection, and there's no claim that what factually occurred did not occur. What occurred was I spoke to Mr. Maxon's sister after he bonded out from Wexford. He was immediately picked up and taken to jail in Gratiot County, which is where he was in October 3rd when we canceled his bond. I spoke to his sister, canceled it with the bond agent. It was confirmed by her to me via text. I attached the text to the motion. The bond agent, since we found out that this took place, they went, and what it appears took place is that they submitted the cancellation paperwork where they had initially filed the paperwork, which was in district court under an FY case. And unfortunately, the FH case, the bond did not get canceled, and that's a mistake. Just purely clerically, where it was filed, it was overlooked. It was a mistaken where they put it into the court. It was a mistake either by the clerk by not bringing it up to the circuit court, or it's an error on the behalf of the bonds person for filing it in the wrong court. But it's hard to imagine, or it's hard to, I can't even figure out how anything other than a ministerial or mechanical act is what is occurring here. The mistake itself doesn't have anything to do with discretion. It wasn't like somebody miscalculated the number of days before something was able to be filed, or use their discretion to see whether or not Mr. Maxon would be entitled to having his jail days be a certain time. Look, the bonds person came in, filed the paperwork on October 3rd. That's when we would just like it adjusted. I'm not looking for extra days. I would just like it to be accurate. I would like the record to be corrected, to be accurate. Not a motion for relief from judgment, not trying to say anybody made a wrong decision. Let's just make the factual chain be what actually factually occurred. And unfortunately, what happened in this case is when the bond paperwork went through, it got on October 3rd, it went through in the wrong court, and it didn't process up. It's hard for me to see that it got canceled at all, but I guess there's something that says it got canceled on March 5th or 6th. But that was after he had already been violated on his bond. There was not actually a bond. There was no requirement that he go sign up to classes. All that had been canceled. So the entire discussion by by the prosecutor is just inapt, and it is not appropriate for what occurred. What occurred is just what occurred. It should have been canceled on October 3rd, not March. I still don't see a document by the bonds person on the March one, but even if it has one, then it's to correct what had taken place on October 3rd. I still haven't seen any submission to counter what the bonds person themselves states or what they submitted to us, which was their fact sheet that shows that all of the ones they canceled that day, including this one, how they did it, the return they received back that showed that it was received by the court. This is their normal process. This is what they followed that day.
All right. I'm gonna need some help on this one. I feel like he said the same thing like 4 times, but in a different way, and I am still kind of confused on what he's actually asking for. So there's an error somewhere, is what he's claiming. There's an error. Whether or not he used the right word or not, it's just a clerical error, something to do with the bondsman. But he's not explaining what the error is. Did I miss that? He started going into it talking about the bond and the dates, but he doesn't actually explain what the error is. So is he saying that the jail time isn't calculated correctly based on the wrong date? Is that what he's trying to argue? I have no idea. Ah, I just feel like that was clear as mud right there. Somebody, please, somebody help me.
I don't think that, and as far as, the smarts of the defense counsel and the smarts of this or that, or how long we waited, that's just not appropriate or to the situation or the motion.
So,
Well, he's in jail, so his bond was canceled. So it has something to do with the bond. So I mean, at least I think we're on the right page with that. But he's in jail. He's the guy in the top left that looks like he's just kind of lounging on a lounge chair. Which, to be fair, I think some defendants need to do that more often instead of running their mouth and just let their attorney talk. Anyways, let's hope we can figure out what's going on here. But it does get better. It gets a lot better. Trust me.
let's be obvious. You're not merely trying to change the date in which his bond was revoked. You're seeking to, in the end, request relief from judgment to have him resentenced and receive credit. Because it would have
I actually think that you, Your Honor, didn't factor that in. In fact, you actually did the right thing when you sentenced. I didn't have any issue. That's why it wasn't a substantive issue. We discussed this, and when it was at his sentencing, you said, "Look, I'm not going to consider that bond violation. There's just too much with regard to that. I'm not going to consider that a bond violation. I'm just going to sentence him just like I have him." And so I didn't have an issue with, as long as you weren't going to consider it a bond violation, it wasn't substantive enough to make the correction. We had 4 other counties we were dealing with on this one, and this was the most heated.
All right, so hold on. Let's go back and address
It gets worse for the attorney. It gets worse for the attorney. It does.
the question that I raised.
Oh, pardon.
The obvious objective here isn't merely to correct an error. You, in the end, wish to seek additional credit for the sentence. Right?
I just want to clarify. Actually, MDOC has filed a motion to clarify something in Macosta. And the only reason I'm filing this is to make sure that the error is accurate.
Hold on.
The record's accurate. I don't know if it's going to affect his sentence at all. It doesn't affect your sentence. The one that you sentenced him to, I didn't have. It's not. It doesn't change anything on it. It just is. It's a record. It just makes sure that record is accurate, and it may apply to something that MDOC is doing right now, but I don't have. I just want to make this correct. I'm not asking for any relief of any sort.
Really? You're not asking for relief now, or is this a step to ask for relief in the future from some other authority? Because I don't think anybody else can change my sentence credit other than me.
I just want the sentence credit to be accurate, and there is a court.
Time out. Stop talking. Hold on. You already.
Oh man, whoever made the Dr. Evil joke earlier, I mean, Mr. Bigglesworth just walked by, so who knows what's going on.
Said it. You just used the word sentence credit. So, in other words, your request in the end is to request a amendment or change of the sentence. Because you just said sentence credit. So, in other words, in the end, you wish to change, maybe not right now, but later on, the sentence credit, correct? So yes or no?
I think that I believe that what's happening is that MDOC is trying to change the sentence to make it what you're discussing, and I'm trying to keep it in place the way it is. I'm not trying to change a thing, just trying to make sure that the numbers are accurate for their determination.
The MDOC has not sought in this courtroom or issued any letters to this court arguing that the sentence credit is incorrect. So there is no MD.
I love how the interrupting attorney was just interrupted by an interrupting cat. I mean, they're perfect for each other.
There is no evidence of the MDOC seeking to amend the credit in this case. They cannot change it. Only I can. Is that correct?
To correct this, there is not an MDOC motion in this court currently. As I indicated earlier, MDOC is attempting in Mecosta County to change a sentence based on inaccurate information that I believe stems from this court. I am not trying to change what they have done, nor am I trying to change the sentence you've applied. I'm trying to make sure whatever it is that occurs in the future, rolling cascading forward, that as the prosecutor pointed out, that we no longer have people sitting on the hands on this error in the record, that the record get corrected.
All right, so let's go back.
If the form is incorrect, I would ask that the court allow me to withdraw this motion at this point, and I'll refile it next week. I'll adjourn it to next week. This should not have a substantive effect on Mr. Maxon's jail, whether or not I picked the right form to put it. That's also, I believe, a clerical error or some sort that shouldn't be held ministerially or discretionarily against Mr. Maxon.
All right.
So to the degree that this is in fact filed underneath the wrong motion, and it is a motion for relief from judgment that the court's going to interpret as his one bite at the apple, to that degree, I would ask that I be able to correct it to be in the correct form, because this is a ministerial, clerical error. That's it. It's an error, and it should just be corrected. However it cascades out, however it affects the sentence here or there. We spoke about it on the day of his sentencing. It wasn't going to have any impact, and I don't believe that it has had any impact. However, it is now in Mecosta County. There is a motion by MDOC to have it have some sort of impact, and it's long overdue. I would just like the record corrected. If the court would like it under a different court rule, I will put it under a different court rule to make it correct.
Legal fiction. I paused it right when I read that and I started laughing. Yeah, I'm not a cat. Yeah, we know. That was funny. That's a shout. That's a callback to, when was that? 3 years ago? Something. Anyways, I really want him to stop using the word ministerially. I don't know if he's using it correct. He's a lot smarter than I am, allegedly, and I don't think he's using it correct. The chat doesn't think he's using it correct. I don't know, but it doesn't sound like it fits. Okay, let's keep going.
All right, Mr. Burns, hold on. I think you are confused. And when I ask a simple yes or no question, it becomes a multiple paragraph narrative that combines a variety of issues. I'm going to break them apart. Now, earlier, and by the way, you've got, my general advice is before you start calling another party inept, all I'm doing is highlighting. Number one, I get in the beginning because I wanted to help focus your conversation. And you filed a motion referencing the wrong court rules. Now, that was your error. Now stop, make sure you don't say anything until I'm done. I let it go. All I did was try to focus your questions and arguments today, because you also referenced, you did, not me, not the prosecutor, you did. You entitled it a motion for relief from judgment, which, by the way, you did not follow the court rule correctly. And I did follow the court rule correctly when, under paragraph D or section D, I notified you that it would be the one bite at the apple under that motion. Then you said the right thing, that you were withdrawing that portion of the motion. So therefore, the court is not considering it as a 6.502. If you choose later to file a 6502, you and your client have the right to do so, because you and I had that colloquy. And I said I was not going to consider it as a motion for relief from judgment. Now, what that did is it specifically narrowed it down to a motion to correct a clerical error. Now, this is not so much a clerical error, because so far, no one in this court, and there's no evidence that anyone in this court or the clerk's office made an error. If anything, there is an error by the bondsman, that the bondsman went to the wrong court and spoke to the wrong people and may have seek to withdraw the, reinstate the bond. Maybe the clerical error was your client going out and paying the bond and getting out of Wexford County, but that has nothing to do again with this court. So what I'm looking for is where did anyone in the court make a clerical error?
If I may, Your Honor, address, first of all, I used the word inapt, not inept. Inapt
Just
means
answer,
it was not
just
appropriate.
answer the question for once.
I am.
Just
I would
answer-
like to make
stop.
sure that the words we're using are the correct words. I don't like words being placed in my mouth that I didn't use.
Mr.
I never
Burns,
said inept today.
Mr.
I never
Burns,
said
you stop
inept.
talking.
I said inapt.
Mr. Burns, stop talking. You are hereby found in contempt. When I'm talking and I directed your question, if you can't do it, that's your error.
I didn't
I'm
hear
gonna
your
let you
question.
go
I
back and-
didn't know I'm in
no,
contempt.
no,
I didn't
I'm
hear your
still-
question.
Oh man, I didn't know I was in contempt. Yeah, you did. You just heard him say that. Otherwise, you wouldn't have known to say, I didn't know I was in contempt. When the judge says, I find you in contempt, after he told you to stop talking, yeah. And that was like the third or fourth time that you interrupted him when he said, stop it. Stop it. Oh, man. Man. All right. We're only halfway finished with this. How do you think the rest of this hearing is going to go? Let's go.
Sorry, I didn't hear your
Burns?
question, Your Honor.
Mr. Burns, you are infuriating this court. I'm going to go back. I'm going to deal with the contempt in a moment. It will just be a fine. I'm going to go back now and ask you, how did any member of the court, its staff, or the clerk's office for Wexford County commit an error?
When the bond was canceled, they did not transfer it to the circuit court. They did
Was
not
it
cancel the
canceled?
bond that was canceled.
Okay, hold on. Mr. Wiggins.
Your Honor, I think where the confusion is coming in is the bonding agent, according to Mr. Maxon, the bonding agent faxed the request to cancel the bond to the district court.
Right.
The district court, as attached to my response, the register of action shows that was never received. I sat down on Friday. The district court uses an electronic fax system. I sat down with the court administrator on Friday afternoon. She went back to October 3rd. And I believe there were 3 faxes received that day, and none of them were from the bonding agency regarding Mr. Maxon. So it's my contention that the bond cancellation was never received by either court.
And then when it was raised to this court later on, and what did he abscond back in October?
Not necessarily in absconsion. So what happened was he posted bond here. It's my understanding he was transferred from Costa County and then to Gratiot County because he had holds. He was released from Gratiot County in mid-October because he had a medical issue. That was post entering a plea here, but pre-sentencing here. He never presented himself here for testing or GPS tether. He was violated in November. I'm sorry, we were here for sentencing in November, in which it was delayed because of medical issues. It was around March is when we actually did the violation for not having him sign up for testing or GPS tether. My recollection is that this issue was raised at the November hearing, the March hearing, and it was not raised in the January hearing when we were here for sentencing again, but the defendant had one. And then it was raised again when we were finally able to reach sentencing on April 15th. The court had found him in violation of bond back in March. I had raised the issue in the PSI that I would like the bond violation addressed under the evaluation plan. We had a back and forth as to whether or not bond was canceled. At one of the hearings, either the March hearing or the April hearing, you had referenced that you had canceled the bond on March 6th. It was received by your court that day and that you had canceled it that day. At the sentencing hearing, Your Honor had advised that you would not necessarily reference the bond violation, but say something to the effect that there were issues on bond. And that was the last we dealt with this issue. So it's my contention, if it's my turn to argue, it's my.
Yes, that is exactly what's going on. The prosecutor is clearing up everything that the defense attorney messed up. I am going to give props to the defense attorney. He is battling hard for his client right now. Not really sure what he's battling for. Apparently, it's the bond. It wasn't, the date isn't right. So I think that I was right on that. The announcement was thrown out and it wasn't actually canceled yet. Or the announcement was sent, but it wasn't canceled on that day. And I think that the attorney's trying to argue to make sure that the bond was canceled on that day, so that it sounds like he's going to get a couple days extra credit for being in jail. Sounds like, still not really sure, but absolutely, you nailed it. Prosecutor is explaining what's going on. Not his job.
Contention that there is not a clerical issue because the court, neither court, ever received the request to cancel bond. So I don't believe this rises to a clerical issue.
Okay. So now that brings me back to where I thought we would be, and it's exactly what I was highlighting with Mr. Burns, and I now turn back to Mr. Burns. Mr. Burns, again, the question is, who in this courthouse made a clerical error? Or either in the district or circuit court, because there's no proof that either court received it. So therefore, it appears to be an error by your bondsman. Am I right?
If I may,
Yep.
I believe that the terms being used here, it is important that we use the correct terms. And as I was correcting what I had been inappropriately cast with, as if I had said earlier, I'm not trying to take anybody's ability to do their job or whether they've done it correctly into question. Whether the correct rules, however, the appropriate and apt rules are being used, I did take exception to, and I apologize to the court if it misunderstood what I was saying in the sense that it was offensive, and I apologize if I didn't hear the court if it was talking. I was certainly not my intention to speak over the court, so I apologize, and I sincerely take back my contempt if I gave that impression. I was not trying to be contemptuous. It's hard to hear.
I appreciate Mr. Burns. I appreciate it, and I give credit to the fact that we are on Zoom. But I think now for maybe the fourth time, who in this courthouse committed an error, or was it just your bondsman?
I'm not trying to talk over your honor. I wasn't finished there. I was trying to give that answer. I wasn't done with my answer. So along those lines, what I think is the problem here is clerical error, which is a type of error, is being misinterpreted to be only clerks of the court. It is not just clerks of the court that can make clerical errors. Clerical errors happen all the time. And they're done by people who are clerks and people who are not clerks sometimes. In this case, the clerical error that took place was a bond cancellation was put forth to the district court in Wexford County that processed this case, the FY case. It was initially where the bond paperwork was initiated. That is where the bond paperwork was canceled. If it was not done appropriately, I'd like to have an actual hearing and bring that bondsperson in here. But there's no reason that that the prosecutor needs to be swinging at shadows on what happened with the bondsperson, nor is there for me. Let's get them in here and let's see what happened. Is that their normal process? Are they baffled by the fact that the district court doesn't have any cancellations that day when they did all their other cancellations that way and have been doing them? That is clerical work. It is done by two parties, one submitting and one that's actually the clerk that processes it. But just because it's a clerk doesn't mean that they're the only ones that can make the error. Although in this case, I think that an error took place at the circuit court level by not processing the bond paperwork that was submitted, but they couldn't because it was submitted clerically into the wrong court, and then there was not a process from the 84th to get it up. In researching this with other courts actually have a process whereby their district and circuit courts communicate at least on some level on these FH transfer cases, so this doesn't happen. So it is actually transferred over when a bond cancellation notice happens. But if that isn't factually what occurred here, let's set this for a hearing. Let's set this out. Let's adjourn this to a day where I can get subpoenas out or get the bondsperson in, and let's factually find out what happened. because I believe a clerical error took place here, whether it was one of the clerks in the court or whether it was the submission itself that of one person, they actually made the clerical error possibly too. But the court is empowered to correct clerical errors, whatever the source. It doesn't limit the court's clerical error and requirement that you take care of these in a judicial and fair manner to avoid manifest injustice. Just if your clerks did them. It doesn't say that. It says clerical errors. So that's my answer to whether or not factually one took place in this case in your courts.
When was the sentence issued again, Mr.?
Sentence was issued April 15th of this year.
So we're not past.
Approaching 6 months.
Yeah. Mr. Burns,
Yes,
has there been, has
Those legal fiction. Those are the last couple words of the Pledge of Allegiance, right? Yeah, I know I've heard those words put together before.
there been an appeal filed?
there's no appeal.
No, I'm
We're
just
not.
asking. I know, because I'm following the rule.
This
that
was
I'm
all
supposed-
this was all baked in. This was just the last county that we were trying to work through. He's already being punished, and that's what bothers him about this brief. I see all the ad hominems. I see the attempt at a second bite at the apple. It feels like to rehash all his. He did some horrible things, and I don't appreciate it that it has to be dragged again through this. This is a clerical error. I'm just trying to correct the record here.
I know. There's a reason why I asked the question.
Yes.
It's because I'm following the correct court rule. 2.612, which is a civil court rule. I'm following 6.435, which applies to criminal. And the reason why I asked the question about the
Yeah, I'm guessing there was something in a response. Whatever motion that this attorney filed, there was something in the response by the prosecutor that he's saying. Because that's the second time he brought up ad hominem attacks. We don't hear him during this, so it had to have been in a court filing. But that's the only thing that I can think of.
appeal is paragraph D, which talks about if an appeal has been filed, how things must be filed in this court to correct sentences. That's the only reason I asked. Maybe next time follow the right court rule. Now hold
Yes,
on.
correct. I apologize.
So, yeah, it's okay. It's all right. So now the reason why I asked the other question, and I think Mr. Wiggins makes the arguments that he does, and the reason why I asked the question earlier about is the future intent to seek relief, because, by the way, you're the one who drafted the motion, although incorrectly, not in compliance with 6.502, but you're the one who asked for the relief from judgment, and this court rule, the proper court rule, 6.435, talks about if there is a mistake, then there needs to be corrections of the record, which could result in some impact to the defendant. Which, by the way, as the judge, as the neutral officer, I need to be considered. Be concerned with that. So I think some of the things Mr. Wiggins argued and the questions that I asked are because I am focused on, and I think Mr. Wiggins referenced it. Hold on, let me double check. It's been hours now since I've read it. I actually don't take, he didn't talk about that, but he did talk about 6.435, and it does tie together with correcting potentially the sentence. So now the question here again becomes correcting the record. We can, this court can, issue a ruling. However, now what I have is defense requesting, and that's how I'm interpreting it, a request to have an evidentiary hearing. Mr. Wiggins, I think really that's now the question before the court. Do I adjourn it and allow the defense to either one, which I think I'd have to, allow them the time to file a true 6.502 motion. Or I ignore all of that, like I've already said I would, and then I only focus on the 6.435 motion. Do I set it out for a hearing? Now, let's see what you have to say. Go ahead, sir.
Well, Your Honor, I'm in favor of moving forward today. However,
Yeah.
preserving the appellate record and any claims that might come from that, I would have no objection. I do take issue, though, with the fact that because there is no authority that goes through this, at least cited by the defendant, and that is clerical issues extend to anybody. So
Right.
if that means I mistakenly put a trial date on my calendar for a week after the trial is supposed to occur, defendant shows up, I don't show up, there's a default judgment entered without or with prejudice, does that mean I get to come back with a clerical error and say I put it on my calendar wrong?
Sure.
There's no authority that states that.
No,
But like I said, in order to preserve the appellate record and any potential ineffective assistance claim, I am not opposing resetting today's date.
So here's what the court's going to
Can I
do
have a,
now.
can I respond to what he just said?
Yes, sir.
I'm not saying that, that's the type of error that took place in this case. And as far as, whether or not, Mr. Maxon's, error actually was framed correctly, or whether or not there's a hearing, I would just point out to Mr. Wiggins and to the court that I don't believe this is disputed. I believe that the factual allegations of what was put forth, the only reason I think there's a need for a hearing is because Mr. Wiggins says that I believe that he's saying the submissions that the bonds person made are they must be fraudulent or misrepresented because the court never received them, is from based on what he's saying. So that's the factual issue that I'd like to get to the bottom of, is whether or not the court received the documentation. That's really it.
No,
I believe there was no dispute on that. That's the first I'm hearing it this morning. It's also the first I'm hearing the 503 requirement, because it was not in the response brief, which was filed late. Again, we will do what is appropriate. Just when the guy's bonds person, this is completely out of our hands too. This involves another individual. Maybe that's why we should have the factual hearing. Certainly not requiring it, because again, the facts aren't disputed. The bonds person, is a clerical mistake is not the lawyer not showing up to the correct date. A clerical mistake would be the lawyer submitting the paperwork with the wrong date on it. And, I submitted that actually was submitted on the 25th, not the 15th, or it was submitted in 23, not 27. And yeah, that's a clerical error, and it can happen from the attorney. And the attorney putting the wrong date is a malpractice, not showing up if they get defaulted. But I do believe also that he could probably pitch the court on whether or not that rose to the level of an appropriate sanction under the circumstances, because it's not necessarily the type of contemptuous missing of a date or intentional missing of a date that another would be. Clerical errors are different level, and the fact that who commits them is not what makes it clerical.
Okay, hold on just 1 second. I'm going to take just a moment, and I'm not going to allow any further response to it. I'm just going to summarize the point at which I believe we find ourselves. The question here is, I don't think there is a factual question. We know that at least there's no record of anyone receiving this note or whatever from the from the bondsman. Question that Mr. Wiggins focused it on, which is the same one I'm focusing it on, is under 6.435, what governs a clerical error, which is in part largely what the argument was that you were just making. Just a moment.
All right. Well, Judge Elmore's looking this up. Erica. Oh, nope. He was fast. Maybe not. Erica, thank you so much for the 7 months. Why?
We'll know.
All right. I thought it was going to be a longer pause than that. Okay, let me start this for a third time. Erica, thank you so much for the 7 months. I appreciate it. That is awesome. Thank you so much. Also, while I'm paused, I was doing my end of the month stuff for YouTube, and I realized something. I missed a PayPal a little over a week ago. John, I don't want to say your last name. Your first name's John. I don't know who you are in the chat, but I did not give you a shout out or thank you for the PayPal, and I am terribly sorry. Did not mean to miss it. So here's your shout out. Hopefully you're still here, and hopefully you're not upset. I didn't do it on purpose, just didn't see it. So I am sorry, and thank you so much for the PayPal. I do appreciate it. Okay, let's keep going.
Note that the Michigan Court of Appeals in People versus Howell, citation 300 Mich. App 638, a 2013 decision, does say that the defendant is not necessarily entitled to a hearing. Question really could be resolved if we had some reference, and this is what I think Mr. Wiggins is saying, which I agree with, and that is there any legal authority that helps us understand what is considered clerical errors? Now, again, I'm not inviting any comment, because when I read 6.435 parenthetical A, which at least just that paragraph is almost identical to the one in 2.612, although 2.612 and 6.435 all differ thereafter. But the question is who does the clerical error apply to? One moment. And
Of course,
as I was mentioning earlier, when I asked the question about the appeal, if an appeal had been filed, is because there are two separate paragraphs under 6.435 that are applicable. Those are paragraph B and paragraph D. Now, D applies and sends us to different court rules, which we're now don't even need to go into right now because we know we're not there. But paragraph B talks about after giving the parties an opportunity to be heard and provided it has not yet entered the judgment in the case, the court may reconsider and modify, correct, or rescind an order it concludes was erroneous. And I think when Mr. Wiggins was talking about how this was mentioned previously, it was all done before the court gave an order, which is why paragraph B and paragraph D are so important. One moment again, I'm not inviting any comment.
it is sad that the judge has to tell
Not
you.
looking at paragraph C.
It is sad. Attorney, do not talk. Do not talk yet. I'll give you your opportunity to do not talk. All right, while I'm paused, Serena, thank you so much. By the power of Odin. Thank you for the 8 months, Serena. I appreciate it. All right, let's go.
Since that's not the issue. Moment again. By the way, so far, I can do my own research here on the bench in People versus Comer, Comer, 500 Mich. 278, a decision from 2017 so far supports my position and how I interpret 6.435. I'm going to continue. One moment, please.
Hey, Wonder Witch, that sounds exactly like my dating life before I met Heather. Yeah, that might have been a little bad. I thought it was funny though.
one moment, as I think I have found a more recent decision by the Michigan Court of Appeals that addresses this question. In 1 second, as I'm not inviting any further argument or comment. Thank you.
No, not all people from Ohio, just the small little town that's only about 30 minutes from me. Just that part of Ohio. Oh, yeah, that happened. Apparently, it came out that it was fake, but then it was true, and then it was fake, and then it was true. No idea anymore.
In fact, again, when we look at the subparagraphs A and B, maybe there is some argument. And this is why, again, the questions that the court raised to the defense earlier at the very beginning of this conversation, nearly 50 minutes ago, is important. Because we are looking at a clerical mistake or a substantive mistake. Paragraphs A or B. Now, this court is going to make a finding. Number one, the defendant is not entitled to an evidentiary hearing. Number two, defense filed the motion under the wrong court rules. However, we have somewhat clarified that today on the record. We now know that there is no motion for relief from judgment being requested under 6.502, and that the court is going to treat this as a motion as if it were filed correctly under 6.435. Now, the next thing here is the court rules that there is no evidence presented by the defendant that there was a clerical mistake made. In fact, there's no evidence that anyone in the court that is involved in the record, that's the key language from parenthetical A. It says mistakes in judgments, that's not it, or mistakes in orders, that's not the argument, or other parts of the record and errors arising from oversight or omission may be corrected by the court at any time. Now, again, I find that there was no clerical mistake made by anyone in the clerk's office, prosecutor's office, or either court. There may have been an error done by the bonding agent, but we addressed that previously on the record. And that's why Mr. Wiggins did the right thing by going into the record. Because without there being proof, your argument is limited to what I kept asking, to merely what the bondsman did or didn't do. And also, I gave the defense the opportunity, as it sounds, at the time of sentencing and previously, to address it. Now, here becomes where I think the key issue. It is not a clerical error, it is a substantive error. You're asking for the court to correct what would, in effect, argue to amend his sentence or give him increased credit. That means it would be a substantive error. That somewhere along the line, a substance error was created. Now, I think, while it is an unreported case, a recent decision that came out in July 25th of this year by the Michigan Court of Appeals in People versus Gaston, I think I'm online. I think that this was arguably a substantive error and not a clerical error. Therefore, this court denies the motion in its entirety. Mr. Wiggins, if you could please draft an order to that effect.
Your Honor, Your Honor, may I make a record, please?
Of course, he cannot go silent into the night. He cannot. He refuses. He's got to get in the last word. And I will tell you, with him coming out and apologizing for being contemptuous, he may have gotten away with not being held in contempt. But the fact that he still wants to talk, we'll see what happens. How much longer do we have of this? We've only got about 6 minutes left. I've got a question for you guys. Do you want to... I want to raid a channel, and I've raided him before. Now, I raid him because he's a really good friend of mine, but he he's showing the vice president debate tonight. I'm not that much of a political person, so I kind of stay away from that kind of stuff. But I do like supporting him because he is a friend of mine. Just I don't always agree with what he's saying, but he is a nice guy. So if you guys feel like jumping over there, that's who I'm thinking of rating. You guys let me know what you think. Okay, let's go.
Sure, go right ahead.
Thank you. The court is inappropriately finding that the outcome is determining the nature of the act. A discretionary or substantive act is not what is spoken to here. It is talking about the type of error, not the type of outcome from the error. The error itself has nothing to do with substance. It has nothing to do with discretion. It has to do with a ministerial and clerical act that was not done appropriately.
I'm pretty sure it's this attorney versus Judge Elmore. I think that's who's in the debate tonight. Could be wrong. Don't quote me on that, but I think that would be an interesting debate.
And has nothing to do with anybody's discretion or input or thoughtful process or deliberation or discretion. It is a act that is completely perfunctory, mechanical, and involves nothing but process. And in this process, the bonds person submitted paperwork to the court that Mr. Wiggins says he talked to somebody that they don't. I'm the only one that submitted an actual bond paper that was submitted to the court that actually has an actual document that says cancellation of bond October 3rd, and then fax documents that supported it being submitted to the court. There's been nothing from the other side to refute that other than Mr. Wiggins standing up and saying, I talked to some people over there. And they didn't say they say they see it. So
I can address it, Your Honor.
Yeah,
Because that is not, yes, I did talk to the court.
I may finish what I'm saying.
I did attach the register of actions to the brief.
Time out. I got it. All right, Mr. Burns. Finish. I'm going to bend over backwards for what should have been handled in 15 minutes, which, by the way, you should have argued something in your brief, not only again underneath the proper court rules, but some case law to support your opinion. But you have 1 minute to finish your argument. Go.
My argument's finished. This is a clerical error. It just needs to be finished. It just needs to be handled appropriately. If I submitted it under the wrong court rule, I appreciate the court considering under the correct court rule. Thank you for today for doing that. And had not meant to be contemptuous. I'm just frustrated that this is being misinterpreted as a substantive discretionary error when this is a ministerial clerical correction of when a cancellation took place.
All right. I don't know if you guys can see what's going on right now. Hold on. I'm going to take myself off the screen. Judge Elmore just walked off the bench. Judge just got up and walked away. You can see him. I know it's small, but you can see him. You guys can't see my mouse, but he walked off. Hold on. I'm going to play it so you can see him moving.
That's pretty plain on the equity, but we're not looking to get there today. So I get that. So
Mr. Burns, you apologize for being contemptuous, but you keep arguing and saying the same thing. I don't care if you disagree with me.
I'm just making a record.
You may take it. Stop talking. All right. I was getting ready to eliminate the contemptuous issue. The court hereby fines you with $500. Thank you. Next, the court has already made its ruling. If you wish, please take it up with the Court of Appeals. I know several of those judges. I think fairly highly of them. It would have been great if we had had an opinion from them in your brief that might have helped us guide that. I don't see that. I've done some research quickly on the stand, and I don't see anything to support it yet. But I'm a little worried about the Court of Appeals having enough to do. So feel free to file an appeal. I hope they look at it. Or if you want to file a motion for reconsideration after you go back and do the research you should have done in the first place, you may do so. Now, you are also the party who has the burden of proof. Mr. Wiggins is the one who went out and did the job. You didn't. Adjourned. Thank you.
I just want to apologize for any
No,
contemptuous.
we're adjourned. Stop talking.
I just wanted to apologize, Your Honor,
You
for
can
being
go away.
contemptuous as an officer of the court. I
Yeah,
apologize.
yeah. Too late. We're adjourned. Thank you.
Woo! Told you guys that was a good one. I told you. Started off a little confusing. I think we all got to the same page, though. I hope so. I'm still kind of confused, but tell you who was also confused, that attorney. Look at the defendant. The defendant's like, wait a second. Did I have my hearing yet? Did you guys call my case? Am I still here? That guy, he might as well be asleep. All right. I did decide to raid JL Warren with Bridge to the Divide. If it's not for you, no worries. It is not going to be like the Irish Demon raid I did the other night where there was a lot of drama and yelling. JL's not like that. He's very warm and welcoming. So if you jump over there and say hi, he most likely will say hi back. But yeah, if it's not your thing, no worries. I'm not political either, but I just like JL, so I'm going to jump over there and hang out for a little bit, and then I'm going to dip. So if you want to join me, join me. If not, if it's not your thing, enjoy the rest of your evening. But thank you guys so much for hanging out with me tonight. I appreciate it. Thank you so much for the membership milestones. I also appreciate that. And that's all I got. So, yeah. Bridge to the Divide. Here we go. Until next time. Bye.